The four accused former Transnet executives will be back in the Specialised Commercial Crimes Court sitting in the Palm Ridge Magistrates Court in Ekurhuleni on the 6th of October. Brian Molefe, Siyabonga Gama, Anoj, Singh and Thamsanqa Jiyane appeared in court yesterday and were granted bail of 50,000 rand each. They are facing fraud and corruption allegations involving tenders to acquire new locomotives. The accused handed themselves to police in southern Johannesburg to face fresh charges involving the acquisition of the 95 locomotives. Now, in 2022, they were arrested on similar charges involving the procurement of 1,064 locomotives. Joining us for analysis on the Transnet matter is Professor Tshepo H Mongalo. He's Professor of Commercial Law at the University of Cape Town's Faculty of Law and Senior Corporate Law and Corporate Governance Consultant for Tong-MONGALO Corporate Services. Professor, good afternoon. Thank you very much for joining us on the program. So this matter is linked to the 1064 locomotives deal, but is a separate one in a sense that it relates to three contracts. We heard from IDAC yesterday that the documents are voluminous and it's a very complex case. So the state has opted to employ a strategy of having them tried separately. What do you make of this?
Because I think this is the best strategy that they could actually follow, because what happens is the public would sometimes look at the documents, particularly that came from the Zondo Commission, and say there is enough evidence there, not realizing that these matters are all separate matters. And if you deal with it as one matter, which is quite complex, you are going to mess up the entire criminal investigation, and you end up with a situation where there is an acquittal on issues that you should have been dissecting and dealing with them in a way in which you can be able to secure conviction.
I'm sure
remembering that it's also the issue of the standard that you need to prove beyond a reasonable doubt can be quite daunting when we've got complex matters such as the ones that have been pursued against the accused at Transnet.
I'm sure you saw yesterday reaction from some in society who just felt that perhaps it would have been more efficient to just add the charges to that main case. But again, as you state, that given how voluminous and complex this matter is, that perhaps it is better to deal with it piecemeal. But we also heard a bit when our journalists were able to interact with the accused. They went on to stress that they're coming back on the 6th of October. But what is going to happen on the 6th of October is that when it returns, the court or the state will actually be merely giving an indication as to when they can disclose further information because they continue with investigations, which one of the accused, Brian Molefe, went on to state that, why are you still investigating if this matter now is from 2014, we're in 2025? If you've brought us to court, perhaps you should have your ducks in a row by now.
But I think that also is justifiable in the sense that the matter has been under investigation for a while. It may be something that so they can argue that they have just been brought here on some speculation before the matter is finalized in terms of investigation. And I think the prosecuting authority left this too late for them to be able to deal with this in the way that can actually be done quite promptly. If they are still investigating now, we understand that the issues are quite complex, but I think the time that they have taken now is just way too long. On this particular aspect that they've dissected from the main case, they should have been done with the investigation by now. And for them to still be giving an indication in October, it's just going to be, dragging it too long.
But
and they run the risk of actually the matter being thrown out if it is found that it's unreasonably dragging too long. And that can actually lead to them being, the accused actually finding it easy for them to just get the matter thrown out when in fact it should be something that is investigated and they are accountable for.
So which is which? If there's an appreciation that the matter is complex, is it not better for the state to take its time and investigate that if since 2014 up until now you've been attempting to formulate the charges? Is that not perhaps the more safer route to take as opposed to having charged them a bit earlier on these three contracts that they appeared for yesterday? Charged them earlier on and kept on having that matter remanded. Does that not clog the court roll?
also is something that is a consideration. But given the fact that they would have seen early on when they decided to even dissect these matters, that it would need certain specialist expertise or evidence, they should have started to put their ducks in a row from the time that they identified that these three particular contracts are the ones they are going to concentrate on. And by that time, they should have started to actually think about who they are going to use as expert witnesses to unravel all of the allegations that are made in relation to those three contracts. And I think they could have done this, even if they're doing it now, to actually say that when they come to court, they're just going to be laying out the framework for how the matter is going to be dealt with. I think it's very much unfair. By that time, they should actually be saying that we are ready to go for trial.
And then the matter around the quantum for the bail, there was a big debate. It moved from 200,000 to 50K. Your views on just what we saw play out yesterday?
In the issue of the bail, I think people need to realize that bail is not a measure of already casting a guilt version or guilt verdict on the accused. It's actually a matter of saying whether will the accused be able to stand trial. And if they can still be able to stand trial, and we don't think that they can skip, and it is quite clear that this are not flight risks, I don't see why it could actually be put at a high just because they want to say these matters are serious. But I think that it is actually something that has to be looked at from the perspective of them being able to stand trial more than any other thing. And if we start now saying that this matter has been quite a huge matter in terms of the state capture, and therefore it needs to be prioritized, and therefore we put the bail that is just going to be indicative of the already the guilt version that has already been taken in the public domain or by the court of public opinion, then we are actually doing disservice. And that is not what the law will take into account. And I think by actually putting it at 50K rather than the initial 200,000K will still be acceptable, as long as the matter will see its ventilation in court in a manner that will be aimed at achieving justice in respect of these matters.
And then in closing, what are the prospects of success for the state here?
Yeah, on these three particular contracts, I think because the matters have really been streamlined quite well, I think they can be able to get a guilt conviction on this one, because the evidence is quite, even the preliminary evidence that they have is quite clear as to the fact that they may actually need a miracle, the accused, to actually be able to say that they were not involved ultimately. And therefore, if the National Prosecuting Authority can get very good expert witnesses and also the prosecuting team that is going to be holding to this particular trial to be quite good and up to scratch, and even the investigating officers, I think they can be able to get a conviction on this one.
Professor, thank you very much for your time this afternoon. That's Professor Tshepo Mongalo. He is Professor of Commercial Law at the University of Cape Town's Faculty of Law. He's also Senior Corporate Law and Corporate Governance Consultant at Tong-MONGALO Corporate Services.